What's interesting is your defense that you're raising in act of God is kind of similar to what we see in criminal law. When you're responsible for conduct is behavior, then it's a voluntary act or an omission to act. So for argument's sake, if during the course of a seizure you would have smacked the plaintiff in the face instead of damaging his car, you would not be responsible for that because that would not be a voluntary act. So I am thinking along your lines almost, if this was not a voluntary act by you, is there a responsibility here on your behalf? But on the other hand, you know when you get behind a wheel, you're in possession of a dangerous instrument and there is a real harm there. And I have to work into whether or not I would want the plaintiff to be responsible for something like that. But on the other hand, sir, the damages here that you're asking for are greater than the actual value of the vehicle. The value of the car on the Kelly Blue Book is $39.69, but you're requesting that we give you $5,000, which is $1,000 in excess of that. Because if the insurance company were to get a case like this, they would total your car and all you would get would be the value of the car. So are you able to drive the car now?
Oh, yeah. It drives fine. It just has body damage.
It's got body damage.
Yeah,
I get that. All right, then. Thank you very much. The parties are excused while we deliberate in this matter.
Well, as I pointed out, I was very challenged by the defendant's description of his defense. I mean, Judge Acker, you point out that this is not a moral judgment that we're about to make. It is a legal one, and there's a distinction. And I thought your reference to the assumption of risk was right on the mark also. And Judge Domingo, your explanation of the difference between a voluntary act in the criminal law and the civil law is also very important, because I think ultimately I cannot conclude the analysis should be on the basis of a criminal understanding, because he voluntarily chose to drive. He voluntarily chose to assume the very real risk that he could have a seizure, and even he testified that this is unpredictable. So I think when we analyze it, we have to look at it also. There are other instances where people have lost consciousness, whether it's a heart attack or some other kind of medical condition. And I think since an individual who has and is aware that he has a kind of illness that could cause the loss of consciousness, that individual, when he or she steps into a car, assumes the risk that this could happen. And essentially, I think there may be an even added responsibility for that person to make sure that they're properly insured. And therefore, I think that we can fairly hold the defendant liable for the damages which equate with the value of the car, $4,000. That's the way I see it.
I see it similarly, and I had said the same thing about the assumption of the risk, and that brings you into the civil aspect, and he does. He gets in the car. But the real issue for me is he was uninsured. Had he been insured, the insurance company would have been arguing this case out. The insurance company would have been saying, well, we insured you because you were properly issued a driver's license by the state of California, and so we're insuring you at maybe a higher premium because of your possibility that you could have a seizure. But he was uninsured. And I think we all feel for him and his illness. I think that's really the problem we're having here. It's like this poor guy didn't do this intentionally or voluntarily. And I think that makes it harder to make a fair decision. But I think the reality is he was an uninsured driver and he caused an accident that incurred damages. And I think that I don't want to give the plaintiff more than the value of his car. So I'm not going to give him the $5,000. I'll give him the book value of the car, $3,969, and call it a day.
For all of the reasons that we've all pointed out, there's no reason to shift the burden to this plaintiff. He wasn't doing anything. There's no negligence at all on his part. On the defendant's part, no, he's not morally wrong. He can't control having a seizure, but he knows he has the condition. He knows that the medication's not 100% effective. And he also knows that there's another condition, the dialysis that we learned about from his wife, that can exacerbate the likelihood of seizures. And you could control and protect third parties from all of those risks. As you point out, Patricia, if he just had insurance.
That would have been it. We wouldn't even be here.
I think it's an
Great.
easy case.
We have a verdict.
But family purpose, I'm glad she doesn't let him drive with the kids in the car.
Indeed.
I think she's a very wise wife, as most are.